Here we are again. It's September 18th, 2001, and we're talking about the removal of a state of New Jersey judge on the grounds of his incompetence, his conspiracy to violate constitutional rights of next of kin, and his misconduct and wrongful conduct as a judge in not complying with the Judicial Code of Conduct. That's the canons number 1 through 3, and his oath of office. Let's read the oath real fast. I, Walter Kaprowski Jr., do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New Jersey, that I will bear the faith and allegiance to the same and to the governments established in the United States and in the state under the authority of the people, and that I will perform the duties of judge of the Superior Court faithfully, impartially, and justly to the best of my ability, so help me God. That's the oath of Judge Walter Kaprowski, New Jersey. That was July 19th, 2005. We're reading from the oath, which you can see on the screen in front of you. And of course, the judge is being charged with failing to support the Constitution. Specifically, one of the charges is that he has obstructed the right of pro se litigants to the right to be heard fully, or the full right to be heard in a court of law and a legal proceeding. And he has admitted by his conduct and his words, in his writings and his orders, that he will give better treatment to those who have attorneys and those who are attorneys, and he will reserve unfair treatment by his conduct now, that he reserves unfair treatment to those who do not have attorneys. And if you don't have an attorney, he will repeatedly badger you to get an attorney, which of course is implying that you will be treated better if you have an attorney. So he's established a definite, separate, and unequal system where the pro se litigant is treated in an unequal and partial manner. And his oath again is to act impartially and of course faithfully to the law. And in the case of IMO, in the matter of Robert Johnson, guardianship case IMO, case CP 0136 2009, Chancery Court, New Jersey, the judge has shown that he cannot act in an impartial manner. He has not been faithful to the facts or to the law. In fact, he's engaged in a fabrication of the facts, accusing next of kin of not appearing at hearings, that next of kin never received any notice whatsoever from the court that they needed to appear at a hearing, and of course never received any notice that next of kin would be sanctioned if they did not appear at a hearing. And down the line, example after example, where this judge has treated the pro se litigant and next of kin unfairly. So please, we ask that you support the removal of Judge Walter Kaprowski, the removal of Tara Wilson, who is the clerk of the Surrogate Court, and the removal of Vanessa D. Taylor, who is guardian of the ward, as well as we ask you to support the disbarment of Lawrence and Myerson, James Boutelier, Shonda Navarro Floyd. Those are three attorneys. We ask that you support their removal and this disbarment. Now, if you want to write us, you can write a postcard or a letter, address it to Removal Department JG, 1522 High Point Street, number 9, Los Angeles, California 90035. That's Removal Department JG, 1522 High Point Street, number 9, LA, California 90035. You can just put one initial on the postcard or the letter. You don't have to put anything in the envelope. We'll see your message. If you want to put something in the envelope, you can. You don't have to give your name, address, or phone number. Just a message, that we can forward to Congress, or if you want to write your own congressperson, you can. But anyway, the judge needs to be removed from the bench, or he needs to resign. needs to resign, and all of his decisions of the past 10 years need to be vacated because he is mentally incapable of comprehending the cases before him. He's actually made rulings and used cases that actually are against his own rulings. So again, he's having a comprehension problem. Next of kin in this particular case forwarded him hundreds of pages of documents. I don't know if it's 1,000 pages or 1,500 pages, and the judge maintained that he couldn't understand what the next of kin was saying, and that he needed the next of kin to appear in person because he couldn't understand what hundreds of documents were saying. Uh, so the judge and others, Vanessa D. Taylor, Lawrence N. Myerson, James Boutelier, Shonda M. Floyd, have engaged and have been accused of engaging in bribery, collusion, commingling, real estate fraud, and the improper use of federal tax dollars for socio-economic discrimination against pro se litigants. And the real estate fraud occurred when the judge gave approval to a sale of property, a contract sale of property, in which the conditions were not spelled out in the contract, and only one person objected to that contract of sale. Everybody else went right along with it, and of course the person who objected is the one who the court retaliated against. Eventually, after about 2 months, the court partially withdrew that contract of sale, but of course left in place certain conditions, like the fact that the contract said it was as is. Yet the court approved a what we call a bribe of $36,000 to the proposed buyer, and of course another attorney, a proposed bribe to another attorney. And we call it a bribe because the contract said the property would be sold as is. So this was a unlawful inducement to get this attorney to take out a loan to get the property, and of course the judge rescinded parts of that approval, but still told the guardian to go right ahead and sell the property, even against the objections of one of the next of kin. So this is the type of separate and unequal treatment that goes on in the court of Judge Walter Kropowski. Of course, the judge probably thinks he's being impartial towards next of kin, but of course the Ku Klux Klan thought they were being impartial too. And I think in Nazi Germany, the Nazis thought they were being impartial. Now, this judge has been accused of violating the Ku Klux Klan Act of 1871, which involves the conspiracy of government officials with private citizens to violate the rights of black Americans in the South in the 50s and 60s, might have been in the 40s also. So he's accused of violating the Ku Klux Klan Act, and some have called him the lynching judge. And they've called him the lynching judge because he doesn't have any regard for the facts or the law. He acts from his own personal biased opinion, as he describes it, quote, common sense. Well, I don't know. How many courts are run or supposed to be run by common sense? They're not supposed to be run by common sense. A courtroom is supposed to be based on the facts and the law, not common sense, not what somebody thinks is practical or logical. On law and facts, and this judge is not able to do that, and that's proof right there. He needs to be removed from the bench. As far as guardianship matters go across this country, I think there needs to be a federal law mandating monthly reports to all next of kin and guardianship cases, and if the courts don't comply with that requirement, then there needs to be fines leveled at federal judges and state judges for not complying with that law. That's monthly reports. So I ask that you listening to this today support that also. For the sake of all next of kin and all guardianship matters, there should be monthly reports out to all next of kin. And of course, you have a right as a citizen to object to the Judge Walter Kropowski being on the bench, and that he is improperly using tax dollars for the design of a separate and unequal system in his courtroom, where he is acting outside of his immunity. Excuse me, there, I just lost the video. Sorry. He's acting outside of his immunity and acting outside of his judicial duties. He's established a double standard. In one of the documents that was forwarded to the judge, Vanessa D. Taylor was accused of elderly financial abuse, gross neglect, gross misconduct, bad faith, dishonesty, hostility towards beneficiaries, and the attorneys were accused of unlawfully obstructing access to evidence, lack of candor towards the tribunal, lack of fairness to opposing party, lack of truthfulness in statements to next of kin, and lack of respect for the rights of third persons, and generally misconduct. This was the charges against the attorneys, and of course there was a motion filed against the attorneys and also complaint filed. And in that motion, in that complaint, they admitted these allegations as being true. The way it works in the courtroom is that if there's a complaint or a motion against you and you're aware of it and you don't file a response to it or an opposition, the local rules and case law states that you have admitted it as true. And of course, Mr. Boutelier did attempt to file some papers with the court, but again, they did not comply with the rules of court, and of course, he admitted the allegations as true also. And Mr. Boutelier supposedly represents the ward in this particular matter, Mr. Boutelier and his firm, his law firm, according to him. We're going to read from some documents that were filed with the appellate division. And this was excerpts from the brief that was filed with the appellate division. And these were New Jersey judges Edith K. Payne and Carmen Messano, Messano. And this document was filed August 1st and August 6, 2011 with the appellate division of the New Jersey Superior Court. We're going to quote from this document. Documents show the Chancery Court has directed a separate and unequal system of a more favorable standard for those who have attorneys versus an unequal standard for the pro se litigant, such practice in violation of state and federal constitutions. The March 28th ruling, denial of plaintiff's complaint, that's the next of kin, severely hinders next of kin's ability to assert his rights as a family member and beneficiary, rights granted in the guardianship and by common law. What the judge did is he did some type of sneak attack, trick play, where he didn't notify the next of kin that there was going to be a hearing, and then when the next of kin didn't appear, he attempted to grant a sanction of attorney's fees without even giving notice that he was going to grant sanction. So this is how this court tries to stop next of kin from complaining about misconduct of the guardian, and of course this is how the judge keeps the pro se litigant from exercising their full right to be heard before the court. Going back to the appellate document here, the January 13th complaint addresses obstruction, concealment of access to evidence, false statements of material fact, harm created by attorneys and Vanessa D. Taylor to plaintiff's right to be kept advised as to Robert Johnson's medical care, residence, and sale of real property, harassment, intimidation, conspiracy, and costs. In this January 13th complaint, all of these allegations were admitted as true by James Boutelier, attorney, Shonda Navarro Floyd, attorney, Lawrence N. Myerson, attorney, and Vanessa D. Taylor. These were allegations admitted as true. Back to the complaint, the court ruling proves that the voluminous documents from plaintiff occurred due to the neglect of duty of defendants, especially the guardian, and her mental and physical inability to respond in good faith. The record shows the concealment, misconduct, lack of full disclosure, and disloyalty of the guardian, Vanessa D. Taylor. And of course, Vanessa D. Taylor is involved with the Taylor Group Insurance Company of Manaus.